You're rolling.
Hello everyone, my name is Amanda, and today I'm going to talk about the 1965 court case, Griswold versus Connecticut. In the state of Connecticut, residents could be fined or imprisoned under an 86-year-old law if they were caught using contraceptives in order to prevent conception. But that soon changed in 1965 when the Griswold versus Connecticut case struck down the 86-year-old law known as the Comstock Law and created the right to privacy for everyone. To help you better understand, I'm going to talk about the origin of the 1879 Comstock Law, as well as the event that broke the law, the case, and the arguments heard in the case, the ruling, and the impact the ruling had on future cases. In preparation for this speech, I read many articles, as well as I also listened to an actual recording of the arguments on os.org. Let's get started with the 1879 Comstock Law. According to PBS.org, Anthony Comstock was a New York postal worker who was disgusted with the prostitution and pornography that he saw in the streets of New York. He believed that the availability of contraceptives was the cause. So in 1873, he traveled to Washington and lobbied for Congress to pass an anti-obscenity bill that would ban the distribution of obscene materials, including contraceptive information and devices. He then went on to smaller states, such as New York, Massachusetts, and Connecticut, and lobbied for them to pass similar laws that would uphold the federal law. In 1879, Connecticut passed a Comstock Law that banned the distribution of contraceptives, information, and devices. But, unlike any other state, they were the first to ban the actual use of contraceptives. Well, now that you're familiar with the law, I'm going to move on to the event that broke the law. I'm going to state the law that Connecticut passed. Any person who uses any drug, medicinal article, or instrument for the purpose of preventing conception shall be fined not less than $50 or imprisoned for not less than 60 days, nor more than 1 year of both fined and imprisoned. And the law also states, any person who assists, abets, counsels, causes hire, or commands another to commit any offense may be prosecuted and punished if he were the principal offender. Well, now I'm going to move on to the event that broke the law. On November 1st, 1961, Estelle Griswold, who was the executive director for Planned Parenthood, and Dr. Seeley Buxton, the chairman department of Yale's Gynecology and Obstetrics, illegally opened a Planned Parenthood with the intentions of challenging a law that they felt unconstitutional. They counseled married couples on how to prevent conception, and after examining the wife, they prescribed contraceptives. On November 10, 1961, Estelle Griswold and Dr. Seeley Buxton were both arrested and charged with breaking the 1879 Comstock Law. This was their goal. Well, now that we have learned about the event, let's move on to the case. According to os.org, Estelle Griswold and Dr. Seeley Buxton had a strong enough case to be heard in front of the U.S. Supreme Court. Their representative, Thomas Emerson, argued in front of the Chief Justice Earl Warren and 9 Associate Justices that the state cannot pass a law that forbids all people to use contraceptives and is forbidden to do so by due process in the First Amendment. He also argued that the law was overbroad because it applies to married couples and to women whose lives may be at risk if they become pregnant. On the other hand, the state of Connecticut's Representative Joseph B. Clark argued that married couples could still practice birth control because abstinence, withdrawal, and the rhythm method are available to married couples in Connecticut. He also argued that the state did have the right to pass a law that's only intention was to reduce the chances of immorality and to act as a deterrent to sexual intercourse outside of marriage. As a result of the case, the ruling, we will now move on to the ruling. During the deliberation, the question that was asked was, does the Constitution protect the right of marital privacy against states' restrictions on couples' ability to be counseled in the use of contraceptives? The state of Connecticut's argument was not strong enough to persuade the 9 Associate Justices to uphold the 1879 Comstock Law. They agreed that the Constitution does protect the right of married couples because there are gray areas in the 1st, 3rd, 4th, 5th, 9th, and 14th Amendment that together create a right to privacy. In other words, the Bill of Rights state individual laws, but when they are together, they create an inherent right to privacy against government invasion of citizen rights. As a result of the ruling, many things were changed. 1879 Comstock Law was struck down, Estelle Griswold and Dr. Seeley Buxton's convictions were reversed, and the right to privacy was created for married couples. Well, now that you're familiar with the ruling, let's move on to the impact the ruling had on other cases. There are many other cases, such as the 1972 Eisenstadt versus Bard. Minors seeking birth control were given the right to do so because the right to privacy was extended to them. Also, in the 1973 Roe versus Wade, the right to privacy was, quote, broad enough to encompass a woman's decision whether or not to terminate pregnancy, unquote. Well, now that you are familiar with the case, I am going to review. To help you better understand the case today, I first explained the 1879 Comstock Law, as well as the event that broke the law, the case and the arguments heard in the case, the ruling and the impact the ruling had on other cases. In conclusion, the 1879 Comstock Law was struck down and the right to privacy was created for everyone. So the next time you make a personal decision, think about the 1879 Comstock Law, the 1965 Griswold versus Connecticut case. It gave you the right to your privacy.
Thank you.
Thank you. Can I change my pictures? I did? Okay.